Well, thank you, Susan, for returning and joining me again. As you all have chimed in, thank you so very much. You listened and watched and gave us great feedback, asked more questions from our first part one. I was able to wrangle Susan back in to do a part two. And so we're going to continue the conversation, talking about some of the challenges that you're facing as a small business owner, as an employer, managing employees. It's not easy. And so hopefully you'll get more of your questions answered today about how do you handle difficult situations. Not only that, but what are some of the changes that are taking place in the law that will potentially impact your business in the way that you do things. So let's get started. Susan.
Krishna, thank you for having me back. This is terrific. I really appreciate the opportunity, and thank you to everyone who's been following your podcast for reaching out and for such great positive feedback. You really are part of a wonderful community.
Oh, thank you. Again, thank you for joining me today. Let's continue the conversation. Let's start off with talking about employee handbooks. You know, a lot of times I hear, I see one of two things. One, either a small business owner does not have an employee handbook. They go, I don't need an employee handbook. My employees know what to do. Or they have taken their former employer's handbook, maybe at a Fortune 100 company, and decided to use that as their employee handbook. Share with me, please. Share with the audience. When we talk about the employee handbook, what are some of the things they need to consider? Is the employee handbook valuable? Just the whole legal perspective.
Well, exactly. One of the things that you just said, opposite sides of the spectrum, both equally dangerous. I'm too small. I've got 10 employees. I don't need a handbook side. And then no problem. I'm using the same handbook I used at a Fortune 500 company. Neither one of these is typically what the average employer needs. Or in the context of the small employer, yes, you want to have an employee handbook. It sets expectations. Employees need to know, and it's fairness, what's expected of them. Once you have a policy in place and it's in writing, it's so much easier to have employees adhere to that policy. And say, why does that matter? Well, if you want to hold an employee accountable in terms of discipline, or even if ultimately it comes to termination, you need to be able to have something to point to say, hey, you were given this process. We didn't treat you differently than anyone else. Everyone is held to the same standard. Even if you're doing that in practice, it makes it very easy for a disgruntled employee to challenge if there's not a policy. Fortunately, courts in all jurisdictions, but I practice in New Jersey and New York, very familiar. Pennsylvania law, however, is the same. They have what's called an affirmative defense for employers. That means if an employee challenges an employer's employment practice and the employer has it in writing, put it in a handbook, implement it. You have to implement what's in the handbook. That's the challenge, right? Because once you have a policy, you have to put it in practice evenly for all employees. So you still can you offer an exception? Maybe, but be careful. When you start offering exceptions, that's where you whittle things down. That's where you want to call HR for your small biz and say, hey, is it okay to do this? And get an outside professional opinion as to whether they offer the exception. But we all want to be human. We want to help people. Right. But at the same time, when is that a good business decision? And when does it help to mitigate risk? But for employers to get that affirmative defense, if you have the policy in practice in writing, and then you have the employee at the end on the last page of the handbook acknowledge receipt. Right. But it's more than just acknowledging receipt. We want to make sure employees say they had a chance to ask their questions. Because some employees will say, well, gosh, I got this, 100-page handbook. How am I supposed to read it? So I signed the last page and turned it back over, all within 5 minutes of receipt, and the employer took it, and that was it, and threw it in the desk. No affirmative defense. That doesn't work. You need to, do you have any questions? Take some time, look at it. And then the gold standard is provide training. Yes. You do not have to provide training on every aspect of the handbook,
Mhm.
right? You don't have to say 9 to 5 or whatever the hours are, but training on anti-discrimination, training on sexual harassment, training on the complaint procedure. That complaint procedure is huge to say, if you have a problem, let me know. How? Employer, what do I do if I feel that I've been discriminated against, if I've been harassed, if I feel I haven't been paid properly?
Right.
Because if the employer doesn't know, they can't reasonably under the law be expected to respond.
Mhm.
So if there's a complaint process, employee complains,
Right.
lets the employer know, hey, this is what's going on, gives the employer a chance to respond. Usually that's an investigation, or maybe it's a correction of wages, something like that.
Right.
All right. That's all key. So the training, it doesn't have to be anything fancy. Gold standard, yes, you want to hire HR for your small biz to come in, right? And
Right.
do the training.
Exactly.
Because then you're getting something full and comprehensive. But I know you'll do different stages of training. You can do, I'm sure, a half an hour to an all-day training, depending on what the workers need. But it's also about training, when I say what the workers need, right? That's one set of training for rank and file contributors. It's another set of training for managers.
Yes, say it again.
Another set of training for your executives, right? Because they all don't need the same thing. They have to know what their rights and what their responsibilities are to the company. So it's often 3 different types of training. Sometimes you need to make sure you're providing training in the language that the employees speak.
Right.
If you have a workforce that is Hispanic or Ukrainian or whatever whatever language is the predominant language, I have a client that their predominant language is Korean. They have to be able to communicate. So you have to provide interpreter in that language to provide the skill set. Have a case right now where the line workers are all Korean and their supervisor is a white male who only speaks English. And consequently, is he really a supervisor?
Right.
He can't communicate. There's nothing he's able to do. And so it raises all kinds of legal questions. And the company's arguing, hey, he's been their supervisor for 15 years. He can't hire. He can't contribute to firing. He can't say anything about productivity. He cannot communicate with them. So, these are all things that come under the broad umbrella of the question about a handbook. The other you asked earlier, you mentioned in your clients and your followers had a lot of interest in what's new in the law. So going back to 2023, the National Labor Relations Board, the NLRB, they're responsible. We think about unions. We think about, labor unions, National Labor Relations Board. It's not just labor unions. Your small businesses with 10, 15, 25 employees, no union in sight, they're responsible to actually to understand and to implement the rules of the NLRB. And that's can be kind of a complicated thing to try and get folks to understand when there's no union.
Right.
And the provision is that you want to hear about is Section 7 of the NLRB. And that's the provision that says employees are allowed to talk about the terms and conditions of their employment, right? So terms and conditions of their employment is a really broad topic.
Right.
That's anything. That's wages. That's their working conditions, sanitary conditions. That's things that safety and health. It is a huge, huge element.
Really
Confidentiality. If you're requiring
yes.
employees to keep confidential information, yes, you can do that, but you have to be careful. If you're in an investigation, you can't say, keep the information we've discussed confidential.
Right.
You have to tie it to legitimate business needs. There's very specific language that needs to be used because you can't do anything that stifles the ability for employees to communicate about terms and conditions of their employment. So that small business with 10 employees are subject. And I have had clients, and one recently that had 11 different small shops all throughout the state. And each shop had part-time workers. No one was really full-time salespeople selling a certain product. And there might be 2 or 3 people at each store, but only one working at a time. overall, there was like less than 20 people. I think they were averaged around 18 employees.
Okay.
National Labor Relations Board came in. Union came in, wanted to unionize these employees. They had to have a vote. Employees voted for unionizing.
Mm.
Very, very divisive vote. And an LRB came in to enforce, and they ended up with a workplace with, by the time it was all said and done, 15 unionized employees.
Wow.
And it was, but you don't know. I mean, it's
Right.
unusual to see,
Mm-hmm.
but it's happening. It's happening in our state.
Right.
A very difficult thing for that employer.
So, and I'm so glad you mentioned where we talk about your pay and some of the things that you're saying, because for my team and even for my clients, that's why I have where people say, well, Krishna, you're doing human resources and you're really pushing the fact that I have a multilingual team. And I'm like, it's necessary. One client in particular, like you said, predominantly Hispanic population. So I do have Hispanic employees on site.
Oh, you
who
do?
are able
That's
to provide
wonderful.
support to them.
Mm-hmm.
We did the orientation and the review of the employee handbook. We had one session in English and we had multiple sessions in Spanish to ensure that those who English was not their primary language was able to get the same education and information.
Are you able then to translate your employer's workplace policies
into Spanish?
Yes,
so if
someone has a policy to translate it,
yes,
that's a really important thing that I would really want all of your listeners to know. Take those policies. If you have a bilingual workforce,
yes, we did the employee handbook was even translated to Spanish.
Okay.
When we did the orientation, it was in Spanish. And then the agreements and everything that they signed was also, one side was in English, the other side was in Spanish.
Okay, that's huge.
So, but I told him, I was like, this isn't, the amazing thing is that this is this client's first time having human resources and having a multilingual staff to support, it's multilingual HR on top of that to support the employees. And the employees have been so grateful. They're like, wow, do you know how long I've been here and I didn't understand these policies. I didn't understand and know that they didn't even understand about their benefits and how to sign it because it wasn't in their native tongue.
So one of the things too that I wanted to jump back in on is talking about understanding. Going through these handbooks, one of the key things is to look at these provisions with respect to the NLRB to see if those policies have what's called a reasonable tendency to interfere with those Section 7 rights. And here's the rub since 2023 for employers, for those small employers. There's a presumption that can be against the employer. So the employer bears the burden of proof that, getting into those legal words, right? But I mean, usually it's the plaintiff, it's the employee typically who bears the burden of proof to say something was wrong. But employers bear the burden of showing that every policy in that handbook has a reasonable tendency, does not have a reasonable tendency to interfere with employees' right to organize, their right to talk about the terms and conditions. So that's another key area where having an employment professional, small business come in and have someone, just even if you have a handbook, it's worth it to have HR for your small biz to read those policies and say, to know what reasonable tendency means, to say, okay, is this a legitimate policy? Because that burden, being on a small business owners have enough burden.
Exactly.
But when you add now a legal burden since 2023 to be able to establish that you're not interfering with those rights, that can be money well spent to have someone take a look.
I tell prospective clients, I'm like, you know what? I need to see your handbook before we even come in and be of service to you, because I need to know what you're committing to, which means what I'm committing to. And for example, I had a small business client who decided they wanted to give unlimited PTO. And
Oh.
because that's what was offered in other companies, and he wanted to compete with the big boys. It's a great idea in theory, but then once he realized the impact to his business that offering that would have, he eventually ended up having to pull that back. And so that's one of the biggest reasons why I tell people, with HR for your small biz, we go through section by section to make sure, can you do everything that's in here? Are you confident and comfortable? And can it be defended if necessary with the decisions that you've made?
So for those clients who want to offer like unlimited PTO, the situation where that works is if compensation is tied to production. Right? So always think, is compensation for this worker tied to production? Like an attorney, right? If I have unlimited PTO, well, that's great. But I don't have the time to take unlimited PTO because I would never be able to service my clients, right? So it doesn't make any sense, right? That I would ever be able to do that because I work by the 10th of the hour, right? Which is what it comes down to. So any employer I've ever had, and I'm a partner, but we always laugh. I have unlimited PTO. I can't manage it more than a 2-week vacation a year. It's just like unlimited sick time. I work sick every lawyer most lawyers work sick because you can't manage a day off. So it's always kind of been like a little bit of a joke, right? In that sense. But if you take that same policy and you put it into administrative support staff, well, that's a whole different element, right?
It really is.
They can take, if you gave them, they could take as much time as they possibly wanted.
Right. And I had that happen to leader one to hyperventilate because one of his key staff members said, "Oh, I need to take 30 days off."
Oh.
And he really couldn't say anything because he put it in the handbook. And he said, I understand. I'm just going to go ahead and go deal with it. And then 5 months later, they submitted another request for another 30 days off. And I was this is why I don't recommend, again, like you said, look at it on a case-by-case basis to make sure, can you fulfill this? But that's enough talk about that.
Yeah, so
let's talk a little bit more about wage and hour and things of that nature, because here is one of the things that I recently went through, and this is not the first time, where employers or managers are upset. They're upset because they have discovered their employees are sharing pay information with one another. And they're like, I want to discipline, I want to write them up, I want to fire them. I can't believe they told them they got the increase, or I gave them a bonus. They're not supposed to be talking about salary. I should be able to just fire them because of that. Share with the audience, share with those who are listening. Are employees allowed to talk about salary with one another? Can they discipline their employees if they're unhappy and have shared information that they view as confidential?
Employees can absolutely talk about their compensation because that is National Labor Relations Act, term and condition of employment. They have to be able to talk about what they're earning and their compensation. Because in New Jersey, we have Diane Biel and Equal Pay Act since 2018, June of 2018, it came into effect. And that act is really important in terms of being able to talk about compensation, particularly for women and for minorities. Because if we're not able to talk about what we're earning and to talk with our male colleagues to find out what they're earning, then how do we know if we're being paid the same amount for doing the same work? Right? So in New Jersey in 2018, 81.3%, women were earning 81.3% as much as men.
Wow.
And that number, that statistic gets dramatically worse when you turn to what Black women were earning compared to white men. It drops to 75%. And I believe it's 60 for Hispanic women. I believe Hispanic women were earning 65% white men. That's 2018.
Right.
I mean, it's a highly significant amount of money. I mean, we're not talking about, some minor dollars and cents here, right? That's the difference between a living wage. That's the difference between where you're living, what kind of rent you're paying, what you're able to do with and for your family. So New Jersey in 2018 said no more. Now, if you say no more, that means you have to allow your employees to have these conversations. And the state's going to protect employees having those conversations. So what is, I guess, Diane B. Allen Equal Pay Act in New Jersey? It's different than the federal Equal Pay Act. The federal Equal Pay Act, which was amended under the Obama administration, Lilly Ledbetter is the name of that amendment, provided equal pay, but you can only challenge if it's gender, if it's male, female. New Jersey, thank goodness, is much broader.
Okay.
New Jersey is looking at everything that's protected under our law against discrimination. So it's looking at race, religion, ethnicity. If it's protected under, if you're, sexual status. Too? Yes, okay. Absolutely. Pregnancy too. All of those things. If it's protected under our law against discrimination, it's protected underneath our Equal Pay Act. Equal pay means is compensation. So pay is not base salary, right? This is much broader. So compensation is your insurance. Compensation is vacation time. Compensation goes into your retirement benefits, bonuses, commissions. All of those things come together for equal pay. And then you have to look at, who is a comparator for equal pay, right? So the phrase is being substantially similar work. Okay. All right. So if you're engaged in substantially similar work, you should be paid the same amount, the compensation when I say be paid, right? So what is substantially similar work? They look at skill, education, experience, training. Okay. Right. So if an employer has a merit system or some type of a hierarchy based on levels where it's tied to merit or longevity, that can be an affirmative defense. That can be a basis for a pay disparity. Right. If someone's working in a place 5 years and someone else 15 doing substantially similar work, well, the person who's there 15 years should be able to be paid more, right? That's fair. Now, if someone is there 12 years and someone else is there 22 years, that's a little bit different still, though, because at some point it has to even out the experience from the position. So it does, that's not necessarily there are other things you're going to have to look at on a case-by-case basis. But substantially similar does not mean you're doing the same job. Does it mean you have to have the same job title? Examples would be like in New Jersey, a janitor in a school system versus a cafeteria worker. Okay, right? They've been found to be substantially similar positions. Skill, training, responsibility. They're doing very different jobs, but in terms of skill, responsibility, training, experience, those are comparable positions. Attorneys, if you're a litigator, you're in court versus someone who does transactional work, very different. There's nothing the same that we're doing the day, right? Not even qualified necessarily for one to do the other, but skill, training, responsibility found to be substantially similar. Okay. So that's a really key piece. So an employee has the right to question an employer and say, hey, I think Tom and I do the same job, and I think a substantially similar job, right? I'd like to know what Tom's compensation is. And the employer has an obligation to conduct maybe an equal pay audit, right? Or to take a look at that and to provide compensation information so that the employee knows whether or not they're being paid properly. Equal pay audits for the employer are something that I do. I'll do them up to about 150, 175 employees. I'll do an equal pay audit. Beyond that, I think, we'll help you find somebody. Beyond that, there's really different tools and things that I think you need to implement that it's worth hiring an actual consultant to come in and to do the audit hand in hand then with using legal staff to evaluate the results. But it's so important to have that sense. And I will tell you, most circumstances when I do the audit, you do find that there is a discrepancy. And I have never had an employer who thought that there was going to be. I have never had an employer who was doing it intentionally. I
Right.
genuinely believe that. Never had anyone who saw it. But when we look at the data
Mm-hmm.
and it all comes out, it does track with
Yes.
the national and the state statistics that I referenced in the beginning.
Mm-hmm.
You can see a difference. To your listeners, what I will say is there's one big source that I think is so important in this that it's come to me,
share it.
which is you don't ask, you don't get. And there are certain cultures and certain groups of people who are more prone to ask. And and I honestly think what I've seen the most is there are trends.
Mm-hmm.
People who are known to negotiate more,
Right.
right? Negotiate. Always ask for more.
Mm-hmm.
So where I see it is in the beginning, people are so happy to get the job, to get
Right.
their foot in the door. They don't want to start off and put a bad taste in the employer's
Mm-hmm.
mouth, right? But that's where it is. Usually this is a lot with the bigger companies.
Mm-hmm.
There's negotiation room. Maybe it's $1,500 that they
Right.
start off higher. But there are folks who negotiated
Mm-hmm.
and came back and they start off $1,500 higher. And they're getting their 3 or their 5% every year.
Mm-hmm.
And it's tracking. And then the bonus is based on what the base.
Mm-hmm.
And you can see this difference. So, why are they getting paid? And then we go back and look, well, why are we being paid more? Oh, what was the wage band that they
Right.
came into? What was, we say, penetration of a wage band, right? How deep into the band? And a lot of times it comes into they asked for more.
Mm-hmm.
And so what I can't say enough, particularly to our female audience on the employee side, is ask. And to employers, it's okay to say no.
Right.
But be careful. Make sure that you're offering and you're treating everyone the same.
Exactly.
If you're going to give more, make sure that's out there. And it's fine to reward people who have the gumption to ask, right?
Right.
That's a quality.
Mm-hmm.
There's something there for somebody who's asking. But I always think, make sure you're doing the same for everyone.
Exactly. And like you said, I love,
Mhm.
I tell my leaders and clients, it's great that if that person deserves it, who has asked for more, to give it to them. But I also remind them, don't forget about, like you said, because sometimes there are cultural reasons why another person isn't speaking up, but they're doing just as good as a job as the
Yes.
person who said, hey, I deserve an increase.
Mhm.
And so a lot of times I go back to them and go, okay, in addition to this person, let's talk about your quiet staff who's performing. Just because they did not ask for it does not mean they should not be considered or given the opportunity to say, here, you know what, they're entitled to it too. Because at the same time, those are the individuals who you run the risk of them potentially even leaving your organization because no, they didn't say anything. And they're like, but wow, you didn't even consider me. And you
Yeah.
know the work that I'm doing. And those are the ones who, as we call it, quiet quitting. They may even stay, but their performance drops. And they're like, what's the point? Because they're not recognizing me for the hard work that I'm doing. And so I keep telling my leaders that, yeah, there's nothing wrong with that squeaky wheel getting the oil, but
Mhm.
there is also such a thing called maintenance and checking everybody.
Yes, I like that. It's
And
maintenance.
so,
That's good.
As HR, it's our responsibility to make sure the maintenance is always being done and to do that pulse check and to smell the smoke before there's fire. But speaking of fires,
Well, I just want to, can I just jump on that
Yes.
a second? Because what you're saying is also, it's good business sense in addition from a legal perspective for risk management, because these are the types of claims that if you don't engage in the maintenance that you just described and looking to the quiet employee, if you get audited and an employee brings a claim, it's 6-year look back. So it's a
Ooh.
2-year statute of limitations under the law against discrimination.
Okay.
But for these Equal Pay Act claims, every paycheck where there's a discrepancy starts your statute of limitations period running.
Wow.
Okay, so every time that there's a discrepancy, you go anew, which basically is every 2 weeks. That's, realistically. You can then go back 6 years to look, right?
Wow.
So you can go back 6 years. There can be all kinds of liquidated damages, and there's attorney's fees and costs awarded to the counsel who brings the claim. Now, even if it's a low-level employee who's making minimum wage, this is a claim that is very desirable for plaintiff's attorneys, because as you said, smoke fire, it's usually there. And it doesn't matter if you're recovering for the employee $5,000 or $50,000. You're going to have to pay those attorneys' fees and costs.
Wow.
Because the thought process from the public policy standpoint is they want employees to be able to challenge. They want attorneys to take the cases. So that's where you end up then paying the attorney fee of $600, $700, $800 an hour, it could even be, to prosecute that claim. And that's where sometimes the bigger expense can be. So when you're looking as a small business and where to put funds, maintenance, maintain the wheel.
And that is so true. I'm so glad you said that. So I hope everyone is listening. A lot of times when you're thinking, HR is an expense and having an attorney is an expense. Not when you're utilizing this the correct way, aka maintenance. You save thousands of dollars, to say the very least, on having an HR person on deck, having an attorney on deck, because it's key. We work hand in hand, HR with your attorney. I call on Susan quite a bit because you just never know, and just having an attorney to bounce those things off of make a huge, huge difference in your business and the success thereof. So we talked about, pay and being able to share some things. I want to hop to overtime and talking about breaks, since we're talking about money, because this is a hot topic in a lot of companies. So let's talk about overtime and breaks. What are some of the things that people need to know and keep top of mind?
I think the biggest issue with the overtime is most employers know 40 hours is the base week. Anything over 40 hours is time and a half. Time and a half of the employee's base salary or base compensation, whether that's hourly, or you could also be if it's a salaried employee, because anyone who's exempt versus not exempt, and we had talked about that the first time, whether you're exempt from overtime, whether you're a professional, whether you're an executive, administrator, computer specialist, some types of sales positions, they're all exempt from overtime. But if it has nothing to do with whether or not you're actually paid a salary or hourly, right? That's not the comp base. But then the employer has to figure out, well, if they're not hourly, what is the employee's actual base salary? Or if they are hourly, and what if they're earning a tip, right, for tipped employees? How do you figure out if they're taking it, if they're taking a tip credit, what's the actual base to put the time and a half on? And I think that's probably the area with overtime where I see the biggest issue is with restaurant workers in particular. So tip credit that's the difference. Just I guess for your listeners who don't know, the tip credit is what the employer can take that pays the difference between the hourly comp and the minimum wage. So that might be maybe someone is waiting tables, they're making $5 an hour, and then that's the difference between the $5 an hour and the 10 minimum wage is what, 15, 16. So in the $10 and change that's on top of that, the employer can take a tip credit for that. That's what allows the employer to pay the employee less on an hourly basis, because the assumption, and the actual requirement is, but the assumption being that the employee is going to make that up and then some in tips. So that's why, tipped employees can be paid less on an hourly basis. So first thing to know about overtime and wage laws is sometimes that first hour or two on a shift, or depending, or maybe it's the last hour, tipped employee is not making that difference, right? They're slow. It's a slow day. It's an outdoor restaurant. It's a rainy day. The employee always has to cover. The employer always has to cover that minimum wage. So when the employee is working, it's covered. But when you're paying overtime, you have to pay it based on the full minimum wage. You have to include the tip credit sum. You can't say, time and a half based on the 5.
Okay.
So they have to get that over piece. that's a really ripe area where I think there's a lot of mistakes for employers there that they're not covering that aspect in the overtime. And then you asked about breaks. So in New Jersey, break time is generally not required.
Okay.
You're not required to give a break if you're over 18. If you're under 18, you have to give a 30-minute break every 5 hours.
Okay.
But if you're over 18, you're not required to get a break. Certainly employers maybe would consider giving a break because just for sheer productivity, how productive can you be without break time? Right. But the key is once you take someone off the clock and say you're giving a half-hour break, you have to give them the half-hour break. You can't have them on the clock and then say, oh, would you please, would you mind, would you run here or there for me and help me with this quick? It'll just take you, it'll take you 5 minutes. Right. And even if it will only take you 5 minutes, just a little thing, or hey, can you grab that call for me? The minute you grab that call, the employee grabs that call, they get paid for the entire break period. That completely stops disintegrates that basis. So what I like to tell employers to do is use the break. If you have a break room, let the employee use the break room. Right. For me, I cannot help myself. I'm like, hey, would you? If I have, for my assistant, they're wonderful. They're right outside of my door. And they're like my right hand. And if I see them at their desk, I am bound to come up with a, hey, would you? Right. And if they're sitting there happily eating lunch at their desk, I might not see that they're eating. And because they're great workers, they're bound to pick up the phone and do something. So it's just not conducive. If there's not a break room, go sit in a conference room someplace, I think that it's a good way to make sure that employers are getting their true break time. So if you're taking, in terms of just breaks that aren't lunch breaks, that's the other piece. Usually 20 minutes is the break period. Okay. If you have a break period for 20 minutes, then they stay on the clock. You're compensating that as an employer. If you're breaking beyond 20 minutes, then they can go off the clock. Okay. So what a lot of employers do, they'll say 15-minute breaks, maybe 2, 1 in the morning, 1 in the afternoon, something like that. And that needs to be compensated time. Okay. Anything else in that category that you see a lot of employees' questions coming up about?
So just making sure that they understand that, again, if you pull an employee or ask them to do work on their break, the clock stops. That you have to pay them for that full time, even though they said, well, only, Krishna had a 40-minute or a 45-minute break, and I only asked them, in 15 minutes before they break in. It doesn't matter. You still have to pay them the 45, correct? Excellent. Because what I've seen, and I've had this happen where an employee issued a complaint about not getting paid or that not being able to take a break. And they came in, I think it was Wage and Hour came in, and that was like my first experience working at a company. And we had told the manager and said, hey, you need to compensate. And the CEO stuck to their guns. And when it was all said and done, paid thousands because they went back like you said, like years.
That's right. And then they didn't only go back. I bet they did. They have liquidated damages. There's the double. And again, if it's Wage and Hour coming in doing the audit, that's intimidating because Wage and Audit will often say, if you're doing it for one, you're doing it for everybody. They're going to look to everybody and they're going to make that correction for everybody. To employers, we may have covered this last time, but to employers who have a complaint that comes in, I cannot emphasize enough. Department of Labor, if they're coming to audit, that is a time to call counsel. That is not a time to have Wage and Hour come into your office. We like to have those meetings in our offices, in our conference rooms. Yes. If you're going through, through HR for a small biz, she'll get a conference room, have them come in. We have our records, because what you don't want to have is, oh, I've got a great conference room in my, at the employer space. And then next thing you know, they start asking questions. And then you're like, oh, let me run and get that. Or, hey, can you pull this document? Yep. We don't want to do anything on the fly. That is not a time for the ad hoc, Just take that, organize that meeting offsite.
Yes. I when I've had that meeting, again, I call you, let's do a tag team.
Mm-hmm.
And I tell managers, do not, or leaders or CEOs, do not go in there by yourself. Do not, like you said, they'll think, oh, it's all right. I'm nice. It'll be okay. The auditor and I can work together. And I'm just like, oh my God, no, don't do it to yourself, because you can put yourself, it can end up being like a rabbit hole that you're going down.
Mm-hmm.
It's like, how deep does it go? Because I've seen them go and start pulling additional files for additional employees, and it just goes on and on and on. And what should have been a day turns into 2, 3, 4 weeks of them just pulling stuff. So
Exactly.
it's very interesting. So let's talk a little bit more about, well, let's switch gears. We've talked a lot about compensation, but one of the hot topics that's going on in our society, in our world right now, are the ICE and coming to the job and things of that nature. So for our small business clients out there, who some of them are very scared, like you said, we have clients who have employee population that would be seriously impacted if ICE came to visit their site, potentially seriously impacted.
Yeah.
What suggestions do you have for them? What things are you seeing? What do you want to share just in general about this whole thing?
I think the first thing to do is have a policy, a plan in place. Let's not a time if you think you could have issues to proceed in an ad hoc way.
Yeah.
If you have employees who might have some questionable paperwork, do your own audit before an audit is forced upon you. This way, if you're doing your own audit, you can find out what employees may have an issue. Ask the employee for the documentation. You want to do this privately, have that employee come aside.
Right.
Tell employees, first of all, tell employees in advance you're doing an audit, right? That we're doing this. We're required to overview. We've taken a look. Here's what we've seen that looks like this paperwork is not valid. And then you have to give the employee a reasonable opportunity to provide you with appropriate documentation.
Right.
10 years ago, I think the requirement was, there was some case law out there that said 90 days is a reasonable period of time to provide documentation. That law or that guidance is no longer valid.
Right.
We now know that it can take up to 120 days to provide certain types of documentation. So it's reasonable, can be a lengthy period of time. The employee doesn't have to provide the employer with any particular document, right? If it's on the list for I-9, they can give anything. So if the first time they gave a passport and the second time they want to give some other documentation, that's completely fine too. The employer should never request documentation.
Right.
If you're getting supplemental documentation, don't backdate the documentation in your system. Take it, staple it behind put it on top and keep the prior documentation behind. So you have, your full record. You don't want to destroy anything, even though you know that the prior document was invalid, because what that document shows perhaps is also, it helps to substantiate you, employer, have been acting in good faith.
Right.
If you find you have somebody who is not authorized to work in the United States, no matter how great of an employee they are, no matter how nice, no matter what, that they've got a wonderful family,
Right.
the reality is it's against the law to continue to employ them, and you have to let them go. You don't have to make a notification, at least not at this time.
Right.
I don't know if that's coming. There is talk that will be coming, but right now you don't have to notify. But you do have to cease employment. And that's to protect your shareholders, your business, your other employees, their livelihoods. Fines are associated. So if, unfortunately, or depending, I guess, if they're not authorized to work, regardless of the circumstance, you need to let that employee go promptly. But in terms of an audit process, if ICE is knocking on your door, you want to find out, do they have a warrant? Is it an administrative warrant or is it a court-issued warrant, right? They don't have to come in and they don't get to just search your workplace without having a judicial warrant, right? So you want to require that. You want to know who's at your door. You want to know a badge number. You want names. You want to take documentation. You don't want to be obstructive in any way, but you have a right to ask these questions. You have a right to look at the warrant. You have a right to make sure that it's not an administrative agency, that it is New Jersey Judicial. You have a right to take a minute to call counsel, to call HR for your small business, to ask some questions.
Right.
Right? You have a right to follow the ICE officers around your workplace. Like, these are things that you're not giving free rein.
Mm.
So certainly that's an important piece to keep in mind with the audits. And again, letting employees know. I think that you're doing your own internal audit, so that in the event there is a federal audit coming down the line, you have that paperwork ready. That paperwork needs to be kept, or should be kept, separate from the personnel file. Keep it in a separate area so that you can pull that documentation without having to go into personnel file and mixing it with other records is really a good best practice as well.
So keeping, when you say this separate, the I-9 documentation separate from the personnel file.
Yes, that can be a good way to make sure that you're having, you don't want to have to open up your personnel files to ICE if that's what it comes down to. And if you're being asked to substantiate an audit, you can easily then pull out your documentation. Here's our internal audit. Let them go through the paperwork if they have a valid warrant.
Right.
And they may come back with one, but again, that might buy you a little bit of time to take a look at your documentation and your processes in place.
So do you hear that? Because actually that's what I recently did for a client. We, like you said, separated out their I-9s. Unfortunately, there were some employees who were not eligible to work or unauthorized to work. Maybe they were when they initially started. And then unfortunately, there were some who submitted fraudulent documentation. So I often tell, again, this is why human resources and HR for your small business is so needed, is because leaders, the CEO doesn't necessarily have the time to get trained in regards to looking at valid Social Security cards, valid IDs, and things like that. And so they're accepting documents that should not be accepted. Sometimes they wouldn't realize that, oh, that's not supposed to be there. It's supposed to be over here, or, oh, these numbers or this font is not right. I've been seeing it all lately, even to the point where for one client in particular, they were quietly accepting and knew they were taking people who should not have been authorized to work, and allowing them, for example, to come in and use. And so I'm sharing this with you so you all will know, don't do this. And so what this person did was they gave their wife's Social Security number. Oh. And so a check was being cut to the wife, but the husband was on the job doing the work.
Oh, I haven't seen
palpitations, the heart palpitations over such things.
Yeah.
Don't do that. I will say this. You cannot outslick the government. Sooner or later, they find out. And so they ended up calling down they did not have me on board when they made these choices. They engaged me because an auditor they thought they were good to go because the person didn't come on site, said, send me, I think they went through like a payroll or workers' comp audit. But somehow or another, the auditor started realizing some discrepancies.
It's not right. Something wasn't good.
Oh. And they were like asking for more, and then said, I need to come on site. And then that's when they were like, oh my God, I think I need someone from HR to help me. So do not get confused in thinking I've been in business, because that's sometimes what I think happens. I have individuals who go, I've been in business for 30 years and I've been doing this and no one has ever said anything or no one has ever called me. It's a different day in time in 2025 going in 2026. The auditors are now back on site. It's no longer COVID. The audits have been happening a lot this year. I just had someone say, and they were like, well, Krishna, for the last 4 years or 3 years, it was just virtual. Well, that's not the case anymore. They're coming on site. They want to see what's going on. They want to be. And so have you been seeing this type of thing too, where audits are taking place and it's on site versus not virtual as much?
I haven't seen the virtual at all since COVID. I see it in the wage and hour. I have not seen the I-9 audits as much. I just, hearing a little bit more about it. The only thing that I've seen in the past year with the I-9 audits that I've been learning about is something you had started off talking about, were what's valid in terms of the Social Security cards and when they're fraudulent and what they look like. And I've heard from employers as to where their employers are getting them. A couple jurisdictions, shocked to hear what they cost and how incredibly affordable this fake documentation is. But then learning how to tell the signs of that, what is fake, and to see what's missing and what isn't. And I've had one employer who did ask, this is last year, asked whether or not what would happen if they were caught. They knew that it was fraudulent, but would it serve as a good faith basis and buy them time? And that's a hard question, because the answer is no. Right. The answer is a hard and fast no, but it's coming from such a good place for the employer. Right. They're genuinely trying to, to help this person who was a great employee and family and all of these good things. But no, the fact that that you're accepting a fraudulent document is not going to give you some type of a safe harbor. Right.
And not only that, but I tell my clients, then the auditor really starts to look, because then they're like, you knew this was fake. You knew you shouldn't have taken it. Now I got to really dig and pay attention to everything that's going on. So I tell them, don't even set yourself up like that. And as difficult as it is, that's why, again, HR counsel's needed, because we can politely navigate that conversation with the employee, with the person that's coming in and applying, and explaining to them, or even transitioning them out. It was difficult. This client in particular lost about 7 of their staff members. Some of them had been there for years, in excess of 10 years. But I had to have the conversation with the person, the employee, and shared with them to help them understand that, although they appreciated the years of service, because they were no longer eligible to work or unauthorized to work, that we had to let them go, that they could potentially be considered for future employment should their documentation gets taken care of. But until then, it jeopardizes the business by having them to continue to remain as an employee of the company. And so I had that conversation, not the manager, but that's what you have HR for. That's what you have your attorneys for, is that we have those conversations. And we provide, if they're comfortable enough, the talking points. I'll call you in a heartbeat, Susan, and go, okay, we need to have this conversation, or can you help this client here and provide them with some additional talking points from a legal perspective of what to say and what not to say, because all those things need to be taken into consideration. True. I think it's one of those things where you're not in court, but still everything can and will be held against you. Your employees, you never know when they're recording you.
True. In New Jersey, very true.
So with that being said, what does that look like in New Jersey if an employee is recording? It
is okay by in New Jersey. It's a single party recording. So as long as one of the persons being recorded knows, so that be you, who's a participant in the communication, knows about the recording, then that's authorized. So what I always recommend employers do, and this goes back to the very beginning of our discussion for the employee handbook, right? Handbooks should have a policy that prohibit employees from recording conversations in the workplace. It doesn't mean that it's illegal for them to do it, but it can be used as a way for you to try and keep that communication out of litigation if you needed to, right? It can put some limitations on whether or not a court's going to let it in. There are arguments that can be made, but it gives you a hook. It gives the employer something to say, hey, that's not right. And it also gives you a policy that they are affirmatively violating, and they're breaking a policy. So you can terminate based on that violation of a policy. And that can, even if they're already terminated based on something else, that employment relationship ceased, this can be a point to cut off damages, because you're in litigation and you find out they're, suing for some type of discrimination, let's say. Then you find out that they recorded you and that there is a bad recording that has somebody saying something pretty darn bad out there. But you have a policy in place that says you can't record. So you now know they violated a policy. You enforced your handbook. They had training on that handbook. They signed the handbook saying they knew. Now what you can do based on that is say, okay, I have after acquired evidence that this employee broke this policy. If I had known about that, I would have fired them for this reason alone. So you're going to cut off damages at that point in time, and they're not going to be able to recover going forward. So hugely powerful for the employer to have that. It doesn't necessarily mean it's not coming in. A good attorney is going to try very hard to keep that out, but that's a judge's decision. But again, it's more about, in the end of the day, it's about the damages.
So it really goes to show you the employee handbook can be a lifesaver in your business if used properly. And I even tell leaders, this is why as HR, I believe in a yearly audit or review of your employee handbook to make sure it's staying current with the law and things like that, because things are always changing.
Well, and I just can't say enough, though, too, about going back to this handbook, because it happens so regular to me. When I get the handbook, that's, the tomb of 100 pages that the 25 employee workplace hands them and says, oh, this is the policy that, my wife at Fortune 500 that they have. So I know if it's good enough for, XYZ fancy company, this is the one for us. Well, no one's reading that.
Right.
You don't need that. You got to whittle that down, make it what's important for your workplace. Right? There are some things that you absolutely need to have, and there is no need. Nobody, and I don't even think the Fortune 500, nobody needs a 100-pager.
Right.
Nobody needs all that. No one's reading that. That's the things in there that don't belong there, and that doesn't help. That goes against you, because you can't reasonably expect someone to read that.
Right. The thing that I always fuss about and tell folks to take out of their employee, they put all these benefits and things that has nothing to do with the being an employee handbook. Can you tell them what an employee handbook, just a quick snapshot or idea of either what should be in the handbook or what should not be in the handbook? Because if I read any more benefits and people just start throwing
the only benefit that you don't want to talk about anything that's your retirement plan. You could have something that says we have this XYZ retirement plan, see benefits provider. Right. We offer medical, dental, vision, see provider. That's one line for each thing. Benefits that you want to include. You want to include your leaves, right? So if you have over 30 employees in New Jersey, that's New Jersey Family Leave Act. If you have over 50 employees, that's Federal Family Medical Leave Act. So you can include those provisions, because that goes to something that's, employee policy. You want to talk about intermittent leave and how they can use those policies, those leave times. So it makes sense to include that. You want to include SAFE Act. That's to help people who are victims of abuse, that they have time off. You want to include sick leave, New Jersey mandatory sick leave. You earn 1 hour for every 30 hours worked, and how that's enforced, and how that time, if you're going to front load it and give the 40 hours up front, or if you're going to accrue it. Those kinds of things you really want to make sure you have, to the extent that those come into, benefits. But the specifics, the nitty gritty, you don't need to have.
Okay.
I think it's always helpful. People want to know if you're giving something extra or beyond what the law requires. So pregnancy is a huge area, right? They want to know, well, what does family medical leave give me? What does New Jersey Family Leave Insurance provide? How does New Jersey Family Leave Insurance work with state short-term disability, right? So you can give a little bit of an overview, but in the end of the day, it's the employee who's submitting those forms, right? So that's, what you want to provide in your handbook is to what extent is the onus on the employee? They can ask about these questions, and you can give direction. But if you're not offering anything beyond what's already, I guess, mandated by the state, then you don't have a need to restate the law.
Right.
A provision that should always be in there, I think, is New Jersey whistleblower law, Conscientious Employee Protection Act, saying employees have a right to say, hey, I think there's a violation of law, public policy that's happening here. If I think that, what do I do? That's where I said the complaint procedure, have a complaint procedure laid out for that. That's an important, should be in every handbook. Complaint procedure for sexual harassment, discrimination laws. Those things are very important. Equal employment policy, very important. We were going to, one of the things that's social media, how to use social media, what those limitations are. But I think, and then of course the termination, right? Is there a 3 strikes you're out? Is there a written warning, and then you're gone?
And that's not even required.
No. It can be once and done. And, are you having, are there performance improvement plans? Will you put them on the PIP? One of the topics that I know we wanted to chat about that I'm now including just this year in all of my employee handbooks is for AI. AI use is huge. We didn't think about this even 2 years ago. I didn't include an AI policy in my handbooks for workers, but now we need, strongly recommend an AI policy. How can employees use it in their workplace? How can, for AI, what's really important is what are you putting into AI in order to, what data does it have in order to give you the output you're looking for? So if you're putting something into ChatGPT, what does that data look like? Is it IP? Is it intellectual property? Is it confidential employee information? Is it your client information? What's being loaded in? Or thinking about what's being loaded in and then the work product comes out. What about plagiarism? How are you crediting that work? How are you utilizing someone else's intellectual property? And how is that being credited in the output? These are all things that you need to think about. What are those limitations? And employees can't be expected to know that. Which type of AI is okay to use and when? And where are the safeguards? It's a wonderful tool. This is a wonderful tool that we need to, keep the training wheels on for a little bit, right? Until we really have a handle on what's happening. So that's the biggest new provision that I think needs to be in each book.
So there you have it. Now you see why Attorney Susan, I just love her. She's with Hill Wallach, has done such awesome work. Matter of fact, I don't want to butcher your name, Swatski.
It is.
So Susan Swatski with Hill Wallach. I can't say enough good things about her, but her contact information is below. As I told you, there's so much more we need to cover. I'm going to see if I can squeeze it one more time for a third session, because the AI non-compete agreements, there's still so much more I have to ask her and we can talk about. But again, if you have some additional questions based off of today's conversation, please put your comments below. Let us know your thoughts on this wonderful, engaging conversation that's meant to help you small business owners, employers, just you as managers. You don't have to wait for your company to pay for your training. Come on over here and join us on YouTube and podcast and learn from us, and we can provide you with guidance as well and the support that you need. But thank you for joining us. My name is Krishna Powell. I'm the CEO of HR for Your Small Biz. And again, my guest today has been Susan Swatski with Hill Wallach. Just Hill Wallach or Hill Wallach and Associates? I want to make sure.
Just Hill Wallach.
Hill Wallach.
Hill Wallach.
But her contact information is below, and so is mine. Thank you all for joining us today.
Thank you. And thank you, Krishna.
My pleasure. Thank you for coming.